Yeah, Kolawole for the claimants, my lord.
Very well.
Respectfully, my lord. O.W. Obaido, appearing for the defendant, my lord.
Please mute your system, because I can hear some noise at the background. Here's the judgment of the court. This action was commenced by general form of complaint filed on 25th of September 2020, wherein claimants claim against the defendant as follows. 1, the sum of 138,290,917 naira 13 kobo being the outstanding unpaid balance salaries and allowances which accrue to the benefits of the claimants during their tenure and by virtue of their position as members of the Legislative Council of Idigbe West Local Government Area of Kogi State has failed to refuse or neglected to pay despite several demands. And 2, interest at the rate of 10% per annum on the sum of 138,290,917 naira 13 kobo from February 2016 to until the judgment is liquidated. It is the claimant's case be the amended statement of fact that they were legislators of the Idigbe West Local Government Area of Kogi State between 2013 and 2016. After their emergence into office, a High Court of Kogi State nullified the election that brought them in, which judgment was later set aside on appeal by the Court of Appeal. However, after their reinstatement pursuant to the other court, the outstanding salaries and other financial benefits was not paid to them. Hence, they filed the suit. They stated that the defendants are indebted to them in the sum of 138,290,917 naira 13 kobo, which is the outstanding unpaid balance of salaries and allowances, including interest, which accrue to the benefit of to their benefits during their tenure by virtue of their position, and which sum the defendants had failed to pay despite repeated demands. Defendants in their defense asserted that the tenure of the first and second claimant as leaders was truncated by the judgment of the High Court of Kogi State, v. the subsequent judgment of the Court of by the High Court of Kogi State, v. a subsequent judgment of the Court of Appeal. They were reinstated back to the office again. Sorry, I will take that again. The defendants in their defense asserted that the tenure of the first and second claimant as leaders was truncated by the judgment of the High Court of Kogi State, but by subsequent judgment of the Court of Appeal, they were reinstated back to office towards the end of their tenure. According to the defendants, the correct salary scale is that of the 2007 remuneration report. It is also the assertion that the judgment of the Court of Appeal made no consequential order as to payment of claimant's salary for the period they were out of office. It is part of the averment that recess allowance was not statutory and not provided for in the revenue salary structure and allowances of the claimants. The defendants asserted that claimants are not owed, nor are they owed the money claimed by them. They went on to state that even when assuming the judgment of Court of Appeal made consequential order of payment of arrears, it won't still amount to the money claimed by claimants. It was contended by the defendant that the claimants were out of office for a period of 9 months, and their entitlements cannot cumulatively be said to be the amount they are claiming. They continue to state that claimants were paid all through 2014, their salaries having left office on 8th of December, and are not entitled to any sum during the period they were removed from office by the judgment of Kogi High Court. More so, claimants upon resumption back to office were paid their salaries and allowances up to they left office in 2016. They maintain that they do not owe the claimants any sum as they were fully paid and as such not entitled to relief salt thereof. On the 6th of December 2021, claimants opened their case And first claimant testified as CW1. He adopted his witness statement and tender documents admitted as Exhibit D to D6. And on the 22nd of February 2022, he was cross-examined by the defendants. On the 15th of June 2022, Can you hear me, please? Learned Counsel, Registrar, you can hear me?
Yes, my
Okay,
lord.
something
Yes, my
kept
lord.
popping. Very well. On the 15th of June 2022, the second claimant also testified as CW2. He equally adopted his written statement and tendered a document marked as SBD7. He was equally cross-examined by the defendants. And on the 12th of October 2022, defendants opened their case by calling one Mrs. Aroye Huife, Mrs. Aroye Huife Law as DW. She equally adopted a witness statement and tender documents admitted and marked as Exhibit A to A2. She was subsequently cross-examined by counsel to the claimants. On the 15th of November 2022, Learned Counsel for the defendants filed their final written address. I have reduced the pertinent part of it into the body of this judgment. Claimants equally filed. I've reduced that also into the body of this judgment. I'll go straight to the decision of the court. After a conscious scrutiny of the general form of complaint, the accompanying processes together with the joint statement of defense, final written addresses of both parties, I am of the respectful view that the issues, the determination of which will do justice to this case are: one, whether claimants have legal standing to institute this action, and two, whether or not the claimants have proven their case to be entitled to the relief sought. Respecting issue one, Learned Counsel for the defendants have argued that claimants lack local standing to institute this action for themselves and on behalf of the legislators of Idigbe West local government area between 2013 to 2016. It is his contention that claimants who are suing in representative capacity have failed to show that they have obtained the authorization of the persons mentioned. I must say that it is not in dispute that there exist councillors of Idigbe, members of Kogi State local government between 2013 to 2016, whom the named claimants who are dominus litis in this instance suit have filed this suit to represent. The law is beyond argument that persons may bring an action in representative capacity in order to seek redress for a wrong done to a group of people, where a group of person or class of persons sought to be represented in the suit are easily identifiable and have common interests and common grievance. A representative suit is in order if the relief sought is in its nature beneficial to all whom the claimant proposed to represent, once it is not challenged that they have common interests. Representative action can be brought. By the 13 Rule 11 of the Civil Procedure Rules of this Court 2017, numerous persons having the same interest in one suit, one or more of such persons may sue or be sued on behalf of or for the benefits of all persons so interested. See the cases of Ogungwa and others versus Williams and another citation captured. The case of Mozi and Mbamalu, citation provided. Adeleke and Anike, citation captured. The DC and Williams International Limited, citation provided. The essence of this kind of action was aptly captured by Sanusi JSC in the case of Doba Hotel PLC and in turn and others, Supra, and I capture it all. The essence of a representative action is mainly to curtail multiplicity or influx of suits on the same interest or matter. Such representative action is competent once the person being represented and the person representing them have common or same interests in the same action, unquote. The courts have often maintained that the rules governing representative action is a rule of convenience and must be treated with some air of flexibility and liberality and not with rigidity. See the cases of Idigbe and others and registered trustees of Anawa, Mimo C&S Church of Nigeria and overseas, citation captured. Sakpo and another versus Sumono, citation captured. The case of Doba Hotel PSC and Itoy and others, Supra. claimants have shown that they have common interests with other unnamed claimants and beliefs sought are common to them all as former councillors and legislators in Yagba West local government. The position of the law is now fairly settled that the proper procedure for challenging a person's authority to represent a group in a suit is by way of a preliminary objection or by motion or notice in limine. Say the cases of Alagwan orders and Benson citation, captured petroleum, there's Elf Petroleum versus Uma and others citation, captured the case of Agbola and Audu citation provided, Wali and others versus Ame Fully and others citation also captured. Defendants in this case did not file any motion or objection challenging the capacity of the two named claimants to sue in representative capacity. They equally did not join issues on this in their pleadings and participated fully in the proceedings and even called evidence. They are raising it for the first time in their final written address. The Court of Appeal, while addressing a similar case, where same issue was raised in the final written address of the defendant for the first time, in the case of Brahima and others and Brahima and others citation capture per Oho JCA held in Tahalia doors, and I quote, a situation whereby the respondents have decided to raise the objections to the appellant's representative status, their written final address is clearly an irregular procedure. Here was even a situation in which the court below had acknowledged that the appellants obtained a requisite leave to sue in a representative capacity, but went out of its way to make erroneous findings on the issue, unquote. The position of the law is clear that once the claimant or claimants express on the writ or statement of claim or fact, as in this instance, that the action was brought in a representative capacity, it is prima facie, though not conclusive evidence of authority by his or their groups to sue in that capacity. In fact, failure to show that a claimant has the authority to sue in representative capacity is not fatal to the case as to vitiate the proceedings or a ground to strike out or dismiss the suit. See on this the case of Ekasa and others versus Ascon, citation captured. Therefore, the submission of learned counsel that the action should be dismissed for failure to show authority to sue is misconceived. In any event, assuming but without conceding that claimants even lack the requisite capacity to sue in representative capacity, defendants, in my view, cannot question same. This is in line with the long settled position of the law that defendant who has nothing to share in the victory of the claimant lacks the locus to challenge the capacity of named claimants who are dominus litis to sue in representative capacity on behalf of other members of the group. See Akinwe Himi and others versus Ore Relay Oil Palm Company Limited citation captured, Elf Petroleum and Uman and others Supra, Director General Bureau of Lands, Kwara State and another, and Surulere and others citation captured. None of the former councillors of Yagba West local government during the stated period who are represented complained or challenged the capacity in which the action was brought or that their interests could not properly be represented by the two named claimants. It is therefore wrong for the defendants to purport to challenge the representative capacity of the claimants on the competence of the action in such capacity. It is in view of all reasons supra that I find that claimants have the requisite locus to institute this action in representative capacity. Issue 1 is thus resolved in favor of the claimants. It is important to note the state of the pleadings of the parties in this case. Defendant had already filed their statement of defense in response to the initial statement of fact filed by the claimants. However, when the claimants amended their statement of facts pursuant to the court order, defendant did not file a consequential amendment to his joint statement of defense. According to law, when the statement of claim is amended, the defendant has a right to amend their statement of defense without seeking leave from the court, but only to the extent necessary to address the new facts presented in the amended statement of claim. However, if the defendant fails to file a consequential amended statement of defense in response to the amended statement of facts, it cannot be considered to have joined issues with the claimant on the new issues raised in the amended statement of claim or facts. This is established in cases such as Usman and First Bank and other citation captured, Mobile Oil Nigeria PLC versus IAL 36 Inc. citation provided. However, it is important to note that a defendant is not obligated to file a consequential amendment in response to a claimant amendment. And the failure to do so does not necessarily mean that the defendant has not defended the action. This is established in the case of Afemi I and others with Stanbic IBTC citation captured. Excuse me, please. Now to the merit of this case. It is not disputed by either side that claimants were ex-councillors or political office holders who were elected in Yagba West Local Council between 2013 to 2016 political dispensation. In fact, the bundles of documents marked as D1 lend credence to the fact that claimants were local government councillors and legislators in Yagba West Local Government during the said political dispensation. Just a minute, Learning Council. It is equally not disputed that the Court of Appeal gave a decision on 23rd of October 2015 in favor of the claimants and other councillors who served between 2013 to 2016 political dispensation in Kogi State, which judgment this court has taken judicial notice of. However, the point of dispute between parties is whether or not the judgment of the appellate court confers benefit of any payment of salaries to the claimants. According to claimants, following the said decision, they wrote a letter dated 15 February 2016 to the defendants, wherein they gave a detailed analysis of the outstanding claims. The said letter is admitted and marked as VD in this case. Defendants, via their joint statement of defense, contended that the judgment of the Court of Appeal made no consequential order as to payment of claimants' salaries for the period they were out of office. They equally averred by paragraph 10 of their joint statement of defense that the decision of the Court of Appeal contains no consequential orders as to payment of salaries to the claimants. They stated that claimants' letter dated 15 February 2016, that is, SVD1, demanding for arrears of salaries contrary to the judgment of the Court of Appeal, and that the computation of salaries written in longhand and attached to the said letter, which is equally part of SVD1, was done by the claimants and in error. See paragraphs 11 and 12 of the joint statement of defense. Then counsel on behalf of defendants equally advanced arguments in respect of this in paragraph 3.30.0 of his final written address, that the judgment of the court contained no consequential order as to salary, and judgment of court is to be given its literal interpretation. In fact, this was a major contention between parties during trial of this case, wherein following conversation ensued during the cross-examination of the first claimant. I quote, question, confirm to the court that you were in office in 2013 to 2016. Answer, yes. Question, are you aware of the judgment of Kogi State High Court delivered on 8th of December 2014? Answer, yes. Question, do you still say that you were in office in 2013 to 2016? Answer, yes, because of the setting aside of the judgment by the court, by the Court of Appeal in 2015 October. Question, when did you resume back to office? Answer, in October 2015. In addressing the, unquote, in addressing the contentions raised by parties as to whether claimants were active in office throughout that political dispensation and the import of the decision of the Court of Appeal, I must state that judicial powers are vested in court by virtue of the provision of Section 6 of the Constitution of Federal Republic of Nigeria 99 as amended, hereafter referred to as Constitution, it is clear that it is not only government authority that are covered in the ambit of judicial powers. Persons other than governments and authority are also encapsulated within judicial powers of court, and no such person shall be able by its domestic arrangement or agreement to remove itself from the general jurisdiction of a competent court. The point must be made that while judicial powers vested in superior courts of record, including this court, does not extend to this court being a court of subordinate jurisdictions to sit as an appeal on the decision of a court of appeal or to subject same to interpretation. This is because judgments of court are unlike documents that can be a subject of interpretation. See the case of the Bado and another and Keystone Bank citation captured, the case of Raise Auto Supply Company Limited and Akib citation equally provided. However, what this court can do is to look at it, that is, look at the judgment and apply the exact terms of the judgment to the case under its consideration by expressing its opinion on the relief sought, taking into account the said judgment. See the case of Bado and another and Keystone Bank Supra, the case of Nigeria Industrial Development Bank and another versus Aki citation captured. It is, in my humble view, that by the Court of appeal judgment setting aside the order of the High Court Kutunkarfi, nullifying the election that brought claimants in. Claimants are thus entitled to be paid for the 10 months, that is January to October 2015, they were out of office by virtue of that judgment. Because the judgment has made the decision of a High Court and their termination invalid. The import of which is that claimants never left office and as such are entitled to be paid for those periods. See the case of Fagwa and another and Idigbe and others cite Supra. The case of Adefulu and others versus Ukulaja and others citation captured. Claimants in this case are claiming the total sum of 138,290,917 naira 13 kobo as the outstanding unpaid salaries and allowances which accrue to them during their tenure, excuse me, and by virtue of their positions as members of the Akwa West Local Government Legislative Council between 2013 to 2016. Defendants, on the other hand, contended that claimants and other councillors were at different times paid the sum of 46,575,487 naira, and at another time paid 12,040,000 naira, and equally paid 2.5 million naira. They also averred that claimants' loan liability to the tune of 14 million naira were equally settled by the defendants. Claimants, by their joint reply, admitted receiving the sum of 46,575,487 naira, but only stated it was just a part payment of their entitlements and that the sum never formed part of their claims before the court. As regards the sum of 12,040,000 naira, which the defendant averred, the claimant did not, in my view, specifically respond to it, as the averments in paragraph 20 of their joint reply on terms of settlement entered with First Bank cannot be said to be in response to that. However, stated in respect of the sum of 2.5 million naira, that their names are not part of those captured in the schedule of payment of voucher attached by the defendant, which is in Exhibit A1. See paragraph 17 to 19 and 21 of the joint reply of the claimants. Claimants in respect of a 14 million loan liability alleged to have been paid by the defendants stated that the terms of settlement was entered into by the first defendant and the First Bank of Nigeria in respect of the salary loan taken by them and strictly the affairs of the defendants, which was done without involving the claimants. The claim of the claimant is no doubt in the realm of special damages. It is Humboldt law that there is need to specifically plead and strictly prove special damages, as the rule requires anyone asking for special damages to prove strictly that is entitled to same. It must be pointed out that the mere fact that the adverse party did not lead evidence to challenge the case of a party claiming special damages would not ipso facto amount to proof of special damages claims, as the claimants are under a duty to prove their special damages claims by credible relevant and verifiable evidence on a balance of probabilities of preponderance of evidence as required by law. Thus, to succeed in a claim for special damages, claimant must plead the special damages and give necessary particulars and adduce credible evidence in support. They must satisfy the court as to how the sum claimed as special damages was quantified. See these cases. Yalaju and others, and Adidi and others citation captured, Copet Construction Limited and Ikisola citation provided, Aluminium Manufacturing Company of Nigeria Limited and Volkswagen of Nigeria Limited citation provided. Claimants in this case by paragraph 13 of the amended statement of fact averred that the sum of 120,290,917 naira 13 kobo out of the total sum of 138,290,917 naira 13 kobo represent the outstanding salaries and allowances, and by paragraph 14 of the amended statement of fact gave particulars of the said sum of 120,290,917 naira 13 kobo. It is expedient for me at this stage to address the contentions raised by parties as to their probative value and admissibility of some of the documents tendered by each party. Then I counsel for the defendants by paragraph 36.0 submitted that SBD5, which is the Legislative Council Impress Outstanding Summary December 2014 to September 2015 and March/April 2016, and SBD3 mentioned are unsigned documents apart from certification and therefore should be disregarded by this court. Ordinarily, the best time to object to the admissibility of a document is when the document is being tendered, failure of which the court will treat the document as admitted, except the document is such of a nature that it is not admissible in law. See the case of Nwoye and FAN citation captured, Clifco, Nigeria Limited, NSIT versus Clifco, Nigeria Limited citation provided, Raimi and Akintoye citation also captured. The point needs to be made that it is the duty of the court to act only on legally admissible evidence, whether the other party objects to it or not. Where the adverse party who is supposed to object fails to do so, the court is empowered to reject such evidence as proprio motu. See the case of Benjamin and Kalio, citation captured, the case of Shitu and Fashawe, citation captured, Dagash and Bulama, citation also provided. It is evident from the records of court that the defendants were absent on the day those exhibits were tendered by claimants, and as such, there was no objection to the admissibility of the documents. However, it is a duty of this court to rely only on legally admissible documents, like I've stated earlier, notwithstanding that there is no objection to its admissibility. It is the law of commonplace that an unsigned document is a worthless piece of paper without evidential value. See the recent case of the Supreme Court, Honorable Solomon Luashe Yuosho and Mr. Debi Adeleke is an unreported suit number SC.BC/7/2023, delivered in May 2023. The case of Jinadu Osurombi Aro, citation captured. The case of Garuba and Kwara Investment Company Limited, citation provided. I perused the said Exhibit D3, and the document was obviously not signed by any of the occupants of the office named who are supposed to sign same. The non-execution of Exhibit D3 taints its genuineness and validity. As such, it is without any evidential or probative value. It is thus discountenanced. I'm also mindful of the submission of learned counsel for the defendants in paragraph 45.0 to 47.0 of his final written address that series of documents attached to Exhibit D4, are undated and unsigned. I perused the said Exhibit D4, and I find that while the letter dated 22nd of June 2016 was signed, the series of documents attached to it, which purports to be series of documents showing the indebtedness of the defendants to the claimants, were both undated and unsigned. It is the law that an undated and unsigned document, as I've stated earlier, has no efficacy in law. See Global Soap and Detergent Industries Limited and NAFDAC citation provided. Thus, those are tied documents which are dated and signed and without probative value and thus discounted.
As the court pleases.
In another breath, There were contentions between parties during trial and in their final written addresses as to the admissibility of Exhibit A1, which is payment vouchers tendered by the defendants in this suit. According to learned counsel for the claimant, the said exhibit is a photocopy of a public document that should have been certified. Learned defense counsel in paragraph 1.0 of his final written address maintained a contrary view that the said exhibit is relevant and as such admissible, and that the document should be admitted in the interest of substantial justice. I've taken a look at the said exhibit A1, and as rightly admitted by parties, the document is no doubt a public document. Ordinarily, by the provision of the Evidence Act 2011 being a public document, the only form of admissible evidence is either the original copy or a duly certified 2 copies of the original, where it is a photocopy as in this instance. See sections 86, subsection 1, 87A, 88, 89E, and F, 91C, and 104, 1, 2, and 3 of the Evidence Act 2011. It must be stated that the defendants pleaded the said document in paragraph 33, 35, and 36 of the Joint Statement of Defense, and the purpose for which it was tendered was to show that claimants and other counsellors were paid the sum of 46,575,487.56, 12,040,000 naira, and 2.5 million naira captured in each of the payment vouchers that made up of Exhibit A1. In all, it is clear that claimants are not challenging the authenticity of the said vouchers because they even made some admissions in respect of the content of Exhibit A1. For the court to be able to know whether the names of the claimant as contended by them is not part of names in the schedule in respect of the 2.5 million naira in Exhibit A1, the said exhibit must be properly scrutinized by the court. The document is from a lawful custody, that is the first defendant, and as stated earlier, its authenticity is not in doubt. It is noteworthy that by the provisions of Section 12 of the National Industrial Code Act 2006, also known as NICA, this court can apply the Evidence Act, but in appropriate circumstances depart from its provisions in the interest of justice, which provision learned counsel for the defendants relied on in his final written address. This is because by its nature, this court is inclined more towards substantial justice. The validity of the above provision of NICA, which empowers this court to depart from the provisions of the Evidence Act in appropriate circumstances, was affirmed by the appellate court in the recent decision of the Court of Appeal Ilorin Division in the case of Mr. Victor Adegui and United Bank for Africa on reported appeal number CA/IL/20/2021, the judgment delivered on 14th of April 2022. I do not think it will be averse to the interest of justice in this case to depart from the provisions of the Evidence Act to admit Exhibit A1. The vouchers and mandate instructions in Exhibit A1 were signed and was issued by the defendant in whose custody it emanated from. Exhibit A1 is thus admissible in evidence. Besides, claimant has reasons, they have admitted some of the payment which Exhibit A1 seeks to prove. Claimants are therefore not challenging the authenticity of Exhibit A1. It is thus relevant to the fact and issue. Accordingly, Exhibit A1 stands admitted and still forms part of the record. Now let me consider the contention of learned claimants counsel to Exhibit A2 on the ground that same is not certified and cannot be admissible. I've taken a look at Exhibit A2, and it is a photocopy of a certified true copy of the terms of settlement before a high court of Oyo State, which clearly falls within the category of public documents. First, learned counsel for the claimants on 12th of October 2022, when Exhibit A2 was sought to be tendered, only objected to the vouchers, which is in Exhibit A1, which have been admitted above. Which still forms part of the record of this court. He never objected to the terms of settlement that is Exhibit A2. What is more, there are divergent views of the appellate court on whether a photocopy of a certified true copy of a public document is not admissible. However, in the case of Magaji and the Nigerian Army, Supra, His Lordship Ogbuagu Jesse held that photocopies of a certified true copy of a public document needs a no further certification. There has been arguments that The views expressed by Ogbuagu JSC is an obiter, owing to the fact that it was expressed in the supporting judgment and the issue was not raised at the Supreme Court. The position of the law is clear that an obiter dictum of the Apex Court, though not binding, may be persuasive. See the case of Terry Holdings and Olua, citation captured, Ferodo Limited and Ibeto Industries Limited, citation captured. Claimants in this case did not object to the document when it was tendered and have not challenged the validity of the content of the said Exhibit 2. In fact, they have not denied that the said terms of settlement was made. Besides, the said photocopy of the certified true copy clearly shows all that is required in certification of the document. It is in the light of this that I will not expunge the said exhibit from the records of this court. Exhibit A2 does still forms part of the record of this court. The above being said, proof of entitlement to special damages or monetary sum is often by reference to an instrument which grants same. Claimants in this case pleaded by paragraph 9 of the amended statement of fact that salaries, allowances, and other entitlements of all political, public, and judicial office holders were last reviewed in 2009 and placed reliance on copies of letters written by the Kogi State House of Assembly dated 6 November 2011 and 21st May 2013. However, they only brought before the court the letter dated 21st of May 2013 written by Kogi State House of Assembly, which is admitted herein as Exhibit D. The said letter will now captivate the attention of this court, and it states thus, I quote, addressed to leaders, Local Government Legislative Council of Kogi State, titled Clarifications on the Entitlements of Local Government Legislative Council Members. Consequent upon a series of requests from the Forum of Leaders of Local Government Legislative Council in the state on the above subject matter, I wish to attach here with photocopy of the data or schedule on salaries and allowances and other fringe benefits or entitlements of leader and other legislative council members of 21 local government legislative council members, that is councillors. 2, the purpose of this is to enable local government councils pay correct entitlements of these officers as duly approved by the Revenue Mobilization, Allocation, and Fiscal Commission in their remuneration report of 2007 and 2009, forwarded to all state governments and House of Assemblies in Nigeria. 3, in view of the above, you may wish to peruse the attached and implement accordingly. 4, thanks, unquote. It is elementary law that where words used in a document are clear, they are to be given their ordinary and plain meaning. See the case of Incorporated Trustees of United Missionary Youth of Nigeria, and Sukubo, citation captured. The case of UBN Limited and Oziki, citation equally captured. The content of Exhibit D captured above is clear, and it is to the effect that salaries and allowances directed to be paid to councillors by the House of Assembly Kogi State is as granted by the Revenue Mobilization, Allocation, and Fiscal Commission, hereinafter referred to as RMAFC. The counsel for the claimants argued in his final written address that the fact that it is a Revenue Mobilization, Allocation, and Fiscal Commission chart of 2009 is what is used to pay claimant is not denied. Learned counsel, again on his own part, submitted that 2009 chart is invalid as the attempt to amend the certain political, public, and judicial office holders' salaries and allowances, etc. Amendment Act 2008, hereafter referred to as the 2008 Act, was unsuccessful, and as such, the applicable law on payment of claimant salaries and other entitlement is the 2008 Act. Acknowledge the argument made by counsel for the defendants in paragraph 21.0 of their final written address that local government political office holders' salary structure, as approved by Revenue Allocation, Mobilization, and Fiscal Commission in 2009, is not valid due to its contravention of a provision in paragraph 32D of Part 1 to the 3rd Schedule, as well as sections 70, 84, 11, and 124 of the Constitution. In addressing these contentions, let me first point out that a court has unfettered right to rely on authorities not cited by parties, as it is not bound to determine a suit only on the authorities cited by them. See the recent decision of the Court of Appeal in the case of Benue State University and Mogaji, citation captured. The case of SPDC Nigeria Limited and others versus Cresta Integrated Natural Resources Limited citation provided, or the case of FHA versus Olayemi and other citation provided. In fact, the court is empowered to take judicial notice of judgments and decisions, especially those of superior courts, and apply them in appropriate or relevant circumstances. See the case of Anyaku Due and Augustine citation captured, the notorious case of Saraki and Kotoye citation captured. None of the parties in this case has cited the decision of the Apex Court. In the case of Nwokedi and Anambra State Government and another, is a 2022 decision of the Supreme Court. But the court has taken judicial notice of the said decision, which is relevant to the resolution of the contentions raised by learned counsel on behalf of the defendants above. In the case of Charles Nwokedi and Anambra State Government and another supra, the Apex Court per Aboki GSC, now retired, had the privilege to consider the above provisions of the Constitution relied on by learned defense counsel vis-a-vis the power of the Revenue Mobilization Commission to fix remuneration for councillors in local government and the power of the House of Assembly to rely on same to make laws fixing remuneration of councillors to be drawn from the Consolidated Revenue Fund of the state. In the above cited case, which this court has relied on in some of its recent decisions on similar issues as in this instance, the Apex Court held that the Constitution or the Revenue Mobilization, Allocation and Fiscal Commission Act, Laws of Federation of Nigeria 2004, hereafter referred to as RAMAC Act, or any other act of the National Assembly do not envisage expanding the scope of political office holders or public officers whose names have not been mentioned either by the Constitution or the Revenue Mobilization Act itself, or any act of the National Assembly, or that the Legislative House, like a State House of Assembly, in that case, the Anambra State House of Assembly cannot expand the scope of the powers of Revenue Mobilization and Allocation Commission on the extent of its powers to fix remuneration for certain persons. The court went further to state that paragraph 32D, item N, part 1 of the third schedule to the Constitution does not expand the scope of the powers of RAMFAC under the Constitution to include councillors. The court was of the view that councillors are not legislators properly so called, as envisaged by the Constitution in section 3181 of the Constitution to bring them under the purview of paragraph 32D of the third schedule to the Constitution. The court also emphatically held that any expenditure that is to be charged upon the Consolidated Revenue Fund under the Constitution shall be as stipulated by section 124(4) of the Constitution of Nigeria. The court held that the consequence of the above is that the inclusion of chairman of local government, vice chairman, secretary to local government, supervisors, special advisors, or PA to the chairman, leader of the local government legislative council, deputy leader, councillors by the Anambra State Law number 7 of 2001, in the list of political office holders or public officers whose salaries shall be fixed by the Revenue Mobilization, Allocation and Fiscal Commission and charged upon the Consolidated Revenue Fund of Anambra State is against the express provision of section 124, subsection 4 of the Constitution. The court in that case notified the provision of the said law as being inconsistent with the provisions of the Constitution. In view of the above decision of the Apex Court, where this court is bound by the Revenue Mobilization and Allocation salary structure as approved by the same Revenue Allocation Commission, which Kogi State House of Assembly relied on to write SBD, which is the basis of claimant's claim, is or travails the Constitution, as the Revenue Mobilization Allocation Fiscal Commission lacks the power to fix remuneration for councillors under paragraph 32D of the Constitution and section 6, subsection 1D of the Revenue Allocation Mobilization and Fiscal Commission Act, and that a lower legislative house, like the Kogi State House of Assembly, cannot expand such powers under the guise of adopting the Revenue Mobilization, Allocation and Fiscal Commission salary structure to councillors, as it did in SBD. Therefore, the part of the claims of the claimant that is based on the remuneration fixed by the Revenue Allocation, Mobilization and Fiscal Commission is not maintainable. I so hold. Assuming the said SBD, which which contains the approved revenue mobilization allocation commission salary structure, is even valid, which fact is not conceded. I do not believe it can justify claimants' claims to the sum claimed. For instance, claimants in this case merely gave particulars of the salary for 2015 to 2016 in paragraph 14 of the amended statement of facts and allotted different amounts to each year. They did not tell the court how they came by the quantum of each of those sums claimed as salary for each claimant in the years 2014, 2015, and 2016. They have not told this court the particular months in respect of which the pleaded sums claimed as salaries of each claimant owed to them for those 3 years. The court cannot speculate on same. It is not enough for claimants to plead the sum each of them is allegedly being owed in each year as salaries. They must go further to plead the months in respect of which those sums are owed, especially where the sum they claim is higher than what SBD documents as their gross monthly entitlements. They cannot claim lump sum as salaries for each of the claimants in each year without showing how they came by the quantum of the sum or for which months in each of those years they are claiming the said sum for. They cannot turn over to the court the duty of trying to get with exactitude by calculations the months in respect of which the lump sum claim for each year by each claimant was gotten. Let's even assume that the series of documents attached to the letter dated 26th of June 2016 in SBD1 showing the alleged indebtedness, which the court have held to be of no efficacy, were even signed and with probative value. They cannot without more justify claimants' entitlement to the said sum because claimants still need to plead how they came by the quantum of the sum claim as outstanding salaries for each of the claimants in each of those years. The bundle of a statement of accounts of claimants and other persons in their group herein as is D6 will equally not be of any help, especially where claimants have not given a distinct particular of how they came by each of the sum claimed as salaries in each year. For each of them in this instance, where the defendants are alleging to have paid claimants some of which have been admitted by them. It is germane to state that monetary claims are not granted as a matter of course or on a platter of gold. They have to be strictly proven. Claimants in this case are equally relying on the letter dated 15 February 2016, hearing as D2 and D4 respectively, which were pleaded in paragraphs 10 to 12 of the amended statement of facts. The averments of defendants in paragraph 14 of the joint statement of defense is that recess allowance is not statutory and are not provided in the Revenue Fiscal Allocation Commission approved salary structure and allowance for political office holders, and those claimants are not entitled to it. Claimants in response by paragraph 7 of their joint replies responded that recess allowance is the same as leave allowance and is captured as number 13 in the Revenue Mobilization Allocation Fiscal Commission approved salary structure for local government political office holders in SBD4. I've taken a close look at both exhibits, that is exhibit D2 and D4 respectively. First, I'm in agreement with the claimants that the recess allowance is also known as leave allowance. Exhibit D2 contains a letter directing the payment of the recess allowance of claimants, which in the attached list is the sum of 1,707,221 naira 20 kobo. I've taken a close look at the breakdown as of the recess allowance for each of the claimants in paragraph 15 of the amended statement of facts, and I find that it matches with what is contained in SBD2. However, as averred by claimants, this leg of claim is also based on the approved salary package, specifically leave allowance by the Revenue Mobilization Allocation and Fiscal Commission, and which payment or salary structure this court has held earlier to be ultra vires. It therefore means that claimants are not entitled to same. Part of the claimant's claim is also for Esther, and in respect of which claimants claim different sums for each of them, as seen in the table at page 14. I must say that there is no document before this court which grants the payment of Esther code to claimants, not even as the D1, which the court has held to be invalid for reasons earlier given, can support the claims of the claimants to Esther code. In the absence of any evidence showing that claimants are entitled to Esther code, I cannot make a finding that they are entitled to same. As such, their claims for payment of Esther code cannot stand, but should fail and thus fails. I've taken note of the fact that claimants in this case are also claiming for payment of interest, which by paragraph 17 of the amended statement of fact forms part of the total sum of 138.2 million naira. According to claimants in paragraph 15 of the amended statement of fact, they're entitled to monthly interest in the sum of 1.5 million naira for running of a legislative arm of government. They are averred by paragraph 16 of the amended statement of fact that the indebtedness of the defendants to them on interest is in the sum of 18 million naira. Claimants failed to plead with distinct particularity item by item with corresponding figures to arrive at the sum of 18 million naira. The averment in paragraphs 15 and 16 is not sufficient to show distinctively how they came by the sum of 18 million naira without them stating distinctively the interest claimed for each month and the corresponding sum to show clearly. Just a minute, Learned Counsel, there is no light here. Just a minute, Learned Counsel, they took the light in Abuja here, just a minute. I will go ahead with the aid of these glasses. The averment in paragraphs 15 and 16 is not sufficient to show distinctively how they came by the sum of 18 million naira without them stating distinctively the interest claim for each month and the corresponding sum to show clearly how they came by the quantum of the sum claimed. It is not the duty of this court to start calculating the months for which they state in paragraph 16 that they are owed the said sum, and then trying to figure out how each month gives a total sum of 18 million naira. In the case of Daniel Holdings Limited and UBA PLC citation captured, Begore GSC CGN retired held those, and I quote, where there is specifically no special damages, it must be proved by evidence clearly showing how the damages arise. Parties should not presume court will be their calculator, an instant computer. Every item of special damage in statement of claim must have clear evidence to support it, unquote. Noteworthy is the fact that the only document which claimants have placed before this court in proof of their entitlement to the said interest is Exhibit D3. I've reasoned earlier in this judgment that Exhibit D3 has no efficacy or evidential value because it is an unsigned document. It therefore means that apart from the claimants failing to plead with particularity, item by item, how they came by 18 million naira claim, they equally have no evidence to ground their entitlement to the sum claim as impressed. This head of claim is refused. Now it will be recorded as stated supra that the defendants in this case are led to have paid claimants the sum of 46,575,487.56 naira in 2016. And claimants admitted the sum was paid to them, but that it was just part payment of the indebtedness of the defendants to them, and that the sum does not form part of the claim of the claimant before this court. It is an elementary principle of law that facts admitted need no further proof. See the case of Sabro Motors Nigeria Limited and Pajav Enterprises Nigeria Limited citation captured. The claimants have admitted they collected the said sum. As such, the defendants do not need to prove same. Claimants who are saying the said sum they admitted collecting from the defendant in 2016 does not form part of their claims in this court have the sole burden to prove that assertion, as he who asserted was proved. It is also tried law, or that a party who desires judgment to be given in his favor on the basis of the existence of certain facts must prove that those facts exist. See the case of Okonkwo and Okolo, citation captured, Ojo and Kamalu, citation provided. Consequently, claimants who would want the court to believe that the sum of 46,575,487.56 paid to them does not form part of their claims before this court, and that the defendants are still owing them to the tune of the money claimed, have the burden to prove same. Defendant, as stated earlier in this judgment, also contended that claimants' loan liability was settled by them to the tune of 14 million naira, with the understanding that it will be deducted from their entitlements, which the claimant did not specifically deny. But their only contention, as I've stated earlier, is that they were not involved in the whole process, as it is entirely the business of the defendants. The defendants, in support of their assertion, rely on the Exhibit A2. I've had a cursory look at Exhibit A2, and it is clear, therefore, that other fellow councillors of Yagba local government whose certificate of return are before this court, excuse me, please. It is clear therefrom that other fellow councillors of Yagba West local government whose certificate of return are before this court in Exhibit D1, except the first and second claimants, were parties to the terms of settlement in Exhibit A2. In essence, only first and second claimants were not debtors under the said terms of a settlement. The only councillors who claimants are representing and claiming on their behalf were debtors and which the ability defendants have settled, and this part is known to the first and second claimants. On the 22nd February 2022, the first claimant was cross-examined and asked the following questions. I quote, "Are you aware of the terms of settlement between First Bank of Nigeria and Honorable Irukera, Lokoja, and 12 others?" Answer, the one I'm aware of is between Irukera, Lokoja, and 12 others and First Bank of Nigeria. Question, are you a party to that? Answer, I was not a party, but became aware because I was their house leader, unquote. It is apparent from the above answers to the cross-examination that even if the two claimants who are dominus litis are not parties to the said Exhibit A2, they are aware that their fellow councillors whose entitlements they are also claiming took a loan from First Bank Nigeria, which the defendants were made to pay. Now the question that agitates the mind of this court is, having not denied the indebtedness of their fellow councillors to First Bank, and the settlement of their loan liability by the defendants, can the claimant validly claim that the defendant are still indebted to these other councillors whose purported salaries and other entitlements the claimant are also claiming in this case? All the above are fatal to the case of the claimant who are claiming for unpaid salaries, allowances, and entitlements for themselves and on behalf of other councillors in Jabba West local government in 2013 to 2016 political dispensation. It is in view of the above that I find that claimants have failed to prove their entitlements to the sum of 138,290,917 naira 13 kobo claimed as outstanding salaries, allowances, and impress. Accordingly, relief 1 in the general form of complaint fails. Now to relief 2, which is for post-judgment interest on the sum claim, and which some claimant have failed to prove. Failure to prove the main monetary claim of special damage sought means the ancillary relief of post-judgment interest have no basis because post-judgment interest cannot be awarded in vacuum. See the case of Udo and others versus Udo and others citation captured, the case of CBN and Okemo citation captured, Akinduro and Alaya citation provided. The principle that ancillary claims will equally fail where main claims fail has its roots in the Latin maxim accessorium secutor principale. An accessory thing goes with the principle to which it is incidental to. It is in the light of this that I find that relief 2 equally fails. It is a tried position of the law that where a claimant fails to prove his claim on the balance of probabilities, the proper order to make is a dismissal of the claim. See the case of Abubu and another and Owonda citation captures Sule and Habu citation provided, Green and Green citation provided. Claimants in this case, having failed in proving their entitlements to the two reliefs claim, are liable to have their case dismissed. It is in the light of all stated that I dismiss claimant's case. Parties are to bear their respective costs. Judgment is accordingly entered.
My Lord, we
I'm
are
most grateful, my Lord.
Lord, we are indeed grateful to the wisdom of the court, to this well taught and delivered judgment. The Lord, we are indeed grateful. It's our prayer that God will bless you and strengthen you and keep you long on the bench, my Lord. We are grateful. We're very grateful.
Thank you. Plain copies will be forwarded to you in Lokoja. Arise from Lokoja.